Officer Dave, would you open the courtroom for us?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Okay, I don't have it here as of yet. Oh, here we go. Dupe and Chewy are here. Good. Chewy. Dupe. 360. Morning, Council.
Good morning.
Morning, how are you doing today?
Glad it's Friday.
Yes,
Yes.
sir.
We are on the record. This is file number 22178-360. Briggs Realty LLC versus Christopher Kelly. Could I have your appearances, gentlemen?
Zachary True appearing on behalf of plaintiff, PA 3966.
Kyle Dupuy for Mr. Kelly, P72892.
Okay, what's our date, gentlemen, for case evaluation?
It is the 18th of April.
April 18th?
Yes.
Okay, then let's have you back. April the 28th. Does that work for everybody?
I'm sure for me, let me just double check.
See.
Yep, that works for me at 10 a.m. again.
At 10 o'clock.
Sounds good.
See you then.
Okay, guys, let's be safe, huh? Okay?
Have a good weekend.
Thanks for
Well.
coming in. Have a great weekend.
You too.
Thank
Sit
you.
down in order today. April 18th.
Good morning, Your Honor.
Newhouse, good morning. I don't have your opponent as of yet, so I'll let you know I knew you were here.
Thank you. Would you like me to give her a call?
I'm sure she's coming.
Okay, thank you.
You appeared last time, and it's 10:04, so you know. People's sense of time is a little more relaxed perhaps than ours. Put you back in the waiting room.
Thank you, Your Honor.
Wasn't too long.
Not too long at all, Your Honor.
Waiting for her to connect the audio. All right, I got visual. No audio. Try it again. All right. All right, we are on the record. This is file number 2219600. Nationwide Mutual Fire Insurance Company versus CR539. Could I have your appearances, please?
Good morning, Your Honor. Abe Newhouse here on behalf of Nationwide.
Bar number.
P85687.
And what is your name, ma'am?
Sherry Hobby.
Okay, are we finished with our written discovery?
Yes.
Okay, then the court will close written discovery. The plaintiff has filed a motion for summary disposition. Have you received that, ma'am?
No, I don't know.
It was sent on or about beginning of February.
The thick package?
Yes, ma'am.
Okay, yes, I received
Oh,
that.
you did receive it. Okay, well, then let's set up the hearing. Your hearing date will be April 28th at 10 o'clock. Ma'am, if you want to file an answer to that, you must file and serve that answer in accord with the Michigan court rules, and you should do that as soon as possible. We'll see.
Okay, just mail it in.
You must serve the other side and the court, ma'am.
Okay, and I thought this was for the discovery, that if I wanted to submit something into the court.
No, ma'am, this isn't, discovery's been closed. We've had discovery open here for several months, and you said it was done, so is there some discovery you want to do?
Your Honor, like I said, I'm not a scholar at law. Yes, I wanted to submit a subpoena for Chantrian Hobby and Ryan Brown to appear on this matter.
Well, ma'am, this is not a trial.
Okay.
If we get to the trial part and you want to subpoena, the court can help you with that, but that's not where we are. So we'll see you April 28th at 10 o'clock, plaintiff's motion for summary disposition. Thank you both for coming in. We are off the record.
Thanks, Judge.
Thank you.
Yes, ma'am. Mr. Polaris, what brings you here
I'm
today?
just gonna turn up my, can you hear me?
Yes, I can. What brings you here today? I don't have a Bank of America case today.
I'm sorry, I think it's just my title on my account is wrong. I'm here for Westlake versus Renato Cooper.
Okay, I don't have Mr. Cooper as of yet. Have you received any pleadings from Mr. Cooper?
I have not, Your Honor.
Okay, let's give him a couple more minutes and then we'll get started.
Excellent, thank you.
We are on the record calling file 22-192086, Westlake Services LLC versus Ronaldo Cooper. By a notice dated March 13th, 2013, this matter is set for hearing today, March 31st at 10 o'clock on the plaintiff's motion to reinstate the case and enter default. Could I have your appearance?
Good morning, Your Honor. Eduardo Polaris, P 63559 on behalf of plaintiff.
Mr. Polaris, have you received any pleadings from the defendant in regard to this motion?
I have not.
Sir, your motion.
Your Honor, we bring this motion pursuant to MCR 2.612C1F. That is the catch-all provision, which allows the court to relieve a party from final order for any reason that the court sees just. In this particular instance, Your Honor, we served the defendant with our lawsuit pursuant to the court's order for alternate service. We also, on top of actually getting a return receipt on the certified mail, giving us reason to believe defendant was actually served, we received a call from the defendant on January 24th after service. So we're confident that he was actually served. However, when we submitted our default, Your Honor, and I'm not sure what happened to our default request. I don't know if the court has record of it, but a week after we submitted our request for default, there was an entry of a dismissal for non-progress. So we don't know if it got lost in the mail or something went wrong here. But regardless, this matter was ripe for default. Our intent was to request default, and somehow the paperwork did not make it to the right place at the right time, and this matter was dismissed. We asked this matter be reinstated and a default enter as the defendant was served. He did not file a response to the lawsuit. He has not filed a response to our motion today.
Counsel, I had a chance to review the file in this matter, and it appears that the second summons was granted in this matter to expire on December 27th, 2022. On December 15th, an order for alternate service was set forth, providing for service by first-class mail, certified mail, and posting by a 36th District Court officer. It appears that the first-class mailing and certified mailing were done December 22nd, and that on December 27th, at the last minute, the posting was done by the 36th District Court officer. The problem is that your paperwork did not catch up to the file. And when the file came in to review for your default, you seem to have several items of your proof missing. In any event, I am confident, based upon the information in the file, that the order for alternate service was complied with in a timely fashion. The defendant failed to appear. The defendant has failed to appear today. Your motion to reinstate the case is granted. The default of the defendant is hereby entered. I note for the record that your file contains the SCRA status report. So all I need from you now is your proposed default judgment and proof of service on the default on the defendant. Thank you for coming in. We'll send out an order for that default today, sir. Have a good day.
Thank you, Your Honor. You too.
Be safe.
You too. Thank you.
Thank you. Presenting classical performances since 1948. Information. That's also more of the story. So. Mr. Spector, what can I do for you today?
Well, I'm here on our motion to reopen a case, Drive Right versus City of Detroit. It's 22195-379.
I have Mr. Bailey. We can get started. Mr. Bailey, what brings you here today?
I think there was a motion up by a plaintiff, Your Honor.
Drive Right versus City of Detroit?
Yes.
Okay, let's call your case. We are on the record. This is file number 22195-379. Drive Right Transportation versus City of Detroit. We have a motion to reopen filed on behalf of the plaintiff. Could I have your appearances?
Yes, sir. Robert Spector on behalf of the plaintiff.
You're a member of the State Bar of Michigan?
I am, and of Florida, sir.
Yeah, you probably have a P number.
I do, 83842, believe it or not. Although I've been practicing in Florida for 47 years.
And so you came here to be cold, is that it?
Well, you know, I'm from up north, so actually I came up to try some cases for a firm up there. I'm an AV rated trial lawyer, and I was trying some cases, and I thought it looked like a good place to have a practice.
Okay, welcome. Counsel, Mr. Bailey.
Calvert Bailey on behalf of defendant City of Detroit, P42409.
Okay, this is Mr. Spector's motion to reopen the case.
Yeah, yes, sir.
Basically, let me make sure I get this right. This case came to me by way of a transfer of venue from 37.
Yes, sir.
And basically it appears that nothing was done after that, but then you filed your default in 37. Is that what happened?
I think it was filed. It was actually filed in yours. But what happened is we got a notification from the court that it was going to be dismissed for basically lack of prosecution. We then filed what was required on the day before the court would have stricken it. Evidently, it never made it in, although we have attached to our motion the stamped document from the court. So Mr. Bailey had originally filed the motion for the change, or his office for the change of venue, and then nothing happened with the case after that. So all we want to do is reopen the case. We'd ask for a default because they hadn't ever filed any responsive pleadings, but we're okay if they just, if the court will reinstate it and allow Mr. Bailey to answer.
Mr. Bailey.
Yes, Your Honor. didn't receive anything other than this notice. We did get the notice it was being dismissed, so
What about the notice of change of venue?
we filed that. We did get that
You
because
got
we
it
filed the
granted,
motion
right?
for changing.
You filed a motion. The
Yes,
motion was granted. But you filed a motion for change of venue, not a dismissal. So when the venue was changed was venue, what did you have to do?
well, yeah, by the time we did anything, that there was an order to dismiss it.
Well, I believe you'll see there's emails to Mr. Bailey's office.
Yeah, because what's happening, Mr. Bailey, is that you won your motion and then you didn't do anything else on the file. You got a motion to change venue. Defendant's motion was granted, and that order was entered September the 2nd. By mid-September, plaintiff's office has sent the American dollars for the transfer fee. And then what happened from your office? Zippo.
Yes, Your Honor.
Indeed,
Pardon?
indeed. I'm not getting why you didn't do anything.
Well, I considered the change of venue motion our first response of pleading. So.
Okay, let's assume that to be true. It's not necessarily accurate, but assume it to be true. It's not a substitute for an answer.
Yes, Your Honor.
And then, having granted the motion been granted, what's your next check? Your next check is to see whether or not the transfer fee is paid, because you don't have to pay it. Plaintiff paid it. And then what do you do? Still having not filed an answer. Zippo.
Yes, Your Honor.
Is there some reason?
No, Your Honor. Again, I considered my motion to be first response of pleading, so.
Under Mr. Bailey, how you've been practicing way too long to tell me that you think a change of venue is an answer.
A response of pleading.
I get this is your first response of pleading. But once the order was granted, did you have any other response of pleadings to file?
I didn't think so, Your Honor.
You didn't think you had to file an answer?
I didn't think I had to do anything further other than, and like I say, by then we got the notice the case was being dismissed.
Mr. Bailey, that didn't come out until January. What were you doing in September and October and November on this file?
On this file?
Zippo.
done-
And all right, here's what I'm going to do. The motion to reinstate the case will be granted. And we'll set the file for pretrial April 28th at 11 o'clock. Mr. Bailey will file his answer within 10 days.
Okay.
Does that date and time work for everybody?
Yes,
Just a second, Your Honor. Yes, it's at 10 o'clock. It does, Your Honor.
At 11 o'clock.
11 o'clock, okay.
All right, gentlemen. Now, while we're here, Mr. Spector, what's your claim about?
it's a PIP claim.
And how
So
much are you seeking?
honestly, I'm covering this. I don't know. I apologize.
All right, so this is what I'm going to do, gentlemen. I'm going to set the matter for pretrial April 28th at 11 o'clock. Mr. Bailey will file his answer within 10 days. Both of you will file the MCI 2.3028 disclosures within 21 days. Anything else we can not accomplish today?
No, sir.
No, Your Honor.
Thank you, gentlemen. Let's be safe. Thanks for coming in.
Thank you, sir.
Thank you, Your Honor.
Have a good day.
Okay.
Counsel,
Good morning, Your Honor.
Mr. Cox, did you receive any pleadings from Doran Banner?
I have not, Your Honor.
All right, let's call your file. We are on the record calling 222000214. The file is entitled City of Southfield versus Doran Banner. By a notice dated March 3rd, 2023, and sent to the parties on that date, this matter scheduled for hearing today, March 31st at 11 o'clock on plaintiff's motion to reinstate the case. It's now 11:14. Could I have your appearance?
Good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff P59146.
Mr. Cox, you got no response from Mr. Banner?
That's correct, Your Honor. We did reach out to Mr. Banner to see if we might resolve this case without having to file this motion or seek concurrence in the motion. He did not respond to my telephone message. And we've not received anything from him today, this morning, or anything in writing in response to the motion.
And he has not appeared today. Please proceed with your motion.
Yeah, Judge, this is plaintiff's motion to set aside dismissal and reinstate case as we set forth in the motion. On the date this court set the matter for pretrial conference, myself and Attorney Susan Winters both had 10 o'clock Zooms prior to this court's 11 o'clock Zoom. And our decision was whoever finished their Zoom first would log in with regards to the 11 o'clock Zoom. We had a miscommunication. Neither attorney from our office logged in. I determined or caught the mistake at about 11:45 that day. This court typically waits anywhere from 15 minutes to 30 minutes. When I logged on, the Zoom room had closed. So I filed the motion probably within an hour, drafted the motion within an hour of missing the court appearance, and filed it with the court the very same day. We're requesting the court put the train back on the tracks, reinstate the case, and reset the matter for pretrial. We don't think we've been repeat offenders in this court, either on this case or on other matters. We're apologetic to both the defendant and the court for missing the hearing, but this is a case that's within the 6-year statute of limitations. And we'd request, based on the defendant's fair joy, to object to the motion that it be granted and the case reset with pretrial.
Counsel, I've had a chance to review your pleadings here. I don't see how there'd be any prejudice to the defendant by reinstating the case. The defendant has failed to appear in opposition. Your unopposed motion to reinstate the case will be granted. The file will be set for pretrial. Pretrial will be April 28th at 11 o'clock.
Very good, Your Honor. With regard to an order, I do not believe we submitted a proposed order.
Did not. I'll handwrite one.
Very good. Thank you, Your Honor.
Thank you. Have a good day and be safe.
You too. Thank you, Your Honor.
Hello?
Hello?
Yeah. Let's get started. We are on the record. This is case number 2224358. Celestine Sanders, Mark Sanders versus Crystal Weaver Smith. Could I have your appearances, please?
Mark Sanders.
Celestine Sanders.
And what is your name, ma'am?
Crystal Weaver Smith.
Okay. This case was started by the filing of a complaint in the small claims division, and then the matter was brought over here. So, Mr. and Mrs. Sanders, what is your claim about?
The tenant owes for rent and damages to the property. She also stole the furnace prior to leaving. A police report was filed. There's a warrant out for her arrest. Currently for the theft of the furnace.
Ms. Weaver, what's your position in this regard?
She is not being truthful. She is not being truthful at all.
Let me ask you this. Am I correct in my understanding that there has been no criminal conviction in regard to the furnace you say was stolen?
Yes, you're correct. No criminal conviction as of yet. There's a warrant out for her arrest. She has spoken to the officer who was investigating the theft, the detective.
Okay.
They just ain't caught up.
All right. What I'm going to do is I'm going to give you written discovery here. I have some very severe Fifth Amendment concerns about a civil matter, which you say involves a crime. I'm sure you can understand what I'm saying to you.
Yes.
So what I'm going to do right now is I'm just going to open your written discovery and I'll give you a return date. And that return date will be April 28th at 11 o'clock. I want to urge you both, Mr. and Mrs. Sanders. I want to urge you, Ms. Weaver. Y'all need counsel, all of you. And this is something that should be done as soon as possible. We'll talk to you.
Your Honor, in addition to the theft, I'm sorry.
I thought I was talking.
I'm sorry.
I swear I thought I was.
I'm sorry.
The written discovery is going to include such things as request for production of documents, request for admissions, and interrogatories. You can go to the Supreme Court's website and it gives you more information concerning written discovery. What did you want to say, ma'am?
I wanted to say the theft of the furnace was in addition to the rent that's owed, which we have a judgment for, and the damages to the property.
You have a judgment for rent owed? Or do you have possession
from landlord tenant?
Or do you have a judgment for payment or possession?
For
do you have
a money for payment? Yeah, we filed for payment.
Okay, so she could either pay or move.
Yes.
Okay, so you do not have a money judgment?
No.
Okay, so I'm going to see you guys April 28th at 11 o'clock. And again, Ms. Weaver, get a lawyer. Mr. and Mrs. Sanders, get a lawyer. Because I have a big problem proceeding in a civil matter with a potential criminal case bound up in that civil matter. The defendant in the criminal case, unlike the defendant in the civil case, defendant in the criminal case has Fifth Amendment right not to testify. And since you say they're outstanding criminal charges, I think we might be well off to get counsel for both sides. And you guys will get back to you April 28th. In the meantime, your written discovery is open. Thank you
Okay.
for coming in.
Thank you.
We'll send
Thank
out a
you.
note to you today.
Alrighty.
That's going to conclude the